Great. Thanks so much, Dan, and thank you everybody around the country for joining us here this afternoon to talk about digital and social media legal issues for broadcasters. As I put here in the title, Looking for Legal Landmines, because that's really what we're going to be doing here today, is looking for issues that can get you into trouble. There's so many legal issues out there in digital and social media issues, and I'm not going to be able to go into depth in every area. It would just be impossible in the hour and a half that we'll spend here today. But what I'm going to try to do is highlight for you those areas where you can get into trouble, the quicksand, the snare, the landmines, where if you go into those areas and you do something, you can find yourself in, running into some legal liability issues. Obviously, the idea is to get you so that you can spot these issues, spot these traps before you get into them, and give somebody a call, your lawyer, your consultant, to make sure that you're not running into problems as you continue with all the digital media efforts that you're doing. You know, obviously, digital and social media has been a big part of broadcasting for the last decade, growing every year. It's probably never been more important, though, than it is right now, where so many of us operating with social distancing from my spare bedroom here today, like I'm sure many of you are working from home. You know, how many Zoom calls have we all had in the last week? You know, life has really changed. So much of it is led virtually now, when there's very few live concerts, very few live music events, very few festivals going on, very few of the non-traditional revenue sources that lots of broadcasters might be using to augment what they're getting through their over-the-air broadcasting. And that really ends up raising some legal liability issues. So in any event, as I said, working virtually creates so many new legal uncertainties that we need to talk about it, and we'll be talking about some of those issues as we move today. It's also created a lot of issues just about some of the rules and regulations that apply to the social and digital media. Obviously, questions about social media have exploded with some of the president's concerns about how social media platforms operate and some of the legal issues that he's raised. So we'll talk about some of those issues as well. You know, really, when we're talking about digital and social media, we're talking about some platforms, some territory that's really been uncharted, that really, in terms of legal developments, is relatively new. You know, you think about legal issues and how long precedents take to develop. There are plenty of FCC proceedings that have been going on, 10 or 15 years. Ownership rulemaking has been going on for 30 or 40 years. Some of the same issues keep getting raised, but a lot of the social media hasn't even been around that long. And the law is such that we don't have a single authority where so much of the regulatory issues are concentrated like we do in broadcasting, where the FCC makes most of the rules. In digital media, there are all sorts of agencies involved in making rules, and some of them are state laws, and some of them are developed through court precedent. So it's not always clear who's in charge and when issues arise. And the issues keep changing every day, as do the platforms, as do the ways that you're communicating with people in digital media. And new laws arising every day. In fact, I'll be talking about a case that just popped up yesterday as we move on here this afternoon. You know, to give you a little perspective, really, Facebook has only been around for about 15 years. 2004 is when it launched for college students. 2006 is when old guys like me and Dan could get on Facebook. Twitter started again 2006. Pandora, YouTube 2005. Netflix didn't start streaming until 2007. Amazon streaming a year before. Craigslist and Monster.com, and I mention those just because essentially they decimated the newspaper industry. They've been around for just 25 years. The iPhone, everybody's got a smartphone, right? Everybody's used to watching video practically on their phone or listening to podcasts and audio on their phone. The iPhone was just 13 years ago, 2007. Zoom, as I said, we're all living on Zoom these days and similar platforms. Zoom just started in 2013. So these are platforms that have been around for 15, maybe 25 years. And yet, when you compare the time that it takes to get regulations and precedent in place in the legal world, that's no time at all. Broadcast regulation, the Communications Act of 1934, it's over 85 years old. We're still fighting about broadcast issues. Copyright. Most of the copyright law really developed in the 1600s in England and has been brought forward, and yet we still have copyright issues all the time. So it's no wonder that there are so many unsettled legal issues in the digital media world that's only been around really for 15 years or less. So the goals for today, as I said earlier, identifying the issues to be aware of, and those issues will fall into different buckets: protecting what you already have, making sure that you don't lose rights to program titles and other branding statements that you may be using in connection with your current operations, not using materials to which you don't have the rights by putting them online and potentially subjecting yourself to liability, thinking about the various tools that you're using online and what rights they give you, what possible liabilities you have because of those platforms, what issues you should be thinking about as you sign up for those platforms. Talk about some cautions about what you should say online, defamation issues, sponsorship identification issues, programming directed to children, how you should handle links to various other content. We'll talk about allowing material from others on your websites, things like user-generated content, essentially the digital equivalent of letters to the editor, people posting comments on your site or posting pictures or videos on sites that you control, including your social media sites. And then finally talk about some of the privacy and security issues that come up in the digital media world that are becoming more and more important. Some of you have already discovered the chat box here that should be, in some cases, I think at the top of your screen by scrolling your mouse over the top of the screen. In some cases, I think you'll find it at the bottom of the screen. You can use the chat box to send questions as we go along, and I'll try to answer them as we're talking here this afternoon. So before we get into all these other agencies that regulate digital and social media, you have to, as broadcasters, we have to think about the FCC itself. And while the FCC itself does not regulate the internet per se, at least not yet, although the president has suggested that maybe the FCC should be looking at social media and how they edit content that's put up on social media sites. At least right now, the FCC has stayed away from content on the internet, but they do require, as part of your broadcast operations in several cases, that you do have a digital media component. For instance, there are restrictions on tying online advertising to references on your website that are referred to in children's television programming. There are restrictions or requirements now that you post links on your homepage of your website to various FCC documents. There were various notices during the course of the digital television transition that you had to put on your homepage. Now there's a requirement that you have a link on your homepage of your website to your FCC online public inspection file. There's a requirement that you have a link on your homepage to your annual EEO public file report. There's a link, and actually don't even have that on this slide, but a requirement that you link to contest rules. If you're not announcing all your contest rules over the air, you can put them on your website, but you need to have a link on your homepage to those contest rules. And the FCC has just announced a requirement that you link directly to any pending applications. While those applications are pending, that was in connection with the FCC loosening the requirements that you do newspaper public notice of many applications. The trade-off is instead you put it on your website and link to those applications in your online public inspection file. Political advertising rules. This is an election year, as unless you've been in a cave someplace, you realize. They don't really apply to pure digital sales, at least not from the FCC, but the FCC does require that if you sell digital advertising on your website or other digital properties in connection with an over-the-air package, that you treat all candidates for the same office in the same way. If you offer it to one candidate, you have to offer that package with the digital opportunities to the other candidates. If you do a package where you allocate, where some of the value is online references for a commercial advertiser, when you're figuring out what the lowest unit rate for the broadcast spots in that package are, you've got to allocate at least some of the value from that package to the digital component. Now, since there's no lowest unit rate from the FCC, you probably don't want to allocate very much to the digital component, but you at least have to recognize that it has some value and then allocate the rest to the over-the-air spots that are subject to lowest unit rate in calculating your lowest unit rate issues. Now, there's one important question that really is kind of unanswered so far. When you run a candidate ad on your broadcast station, that candidate can say all sorts of horrible stuff about their opponent. They can lie through their teeth about their opponent. And as long as the candidate who's making these outrageous statements appears in the ad, they're recognizable voice or images in the ad. And if it's a federal candidate, they have the message that, hey, I'm John Smith and I approve this message. You've got no liability for whatever they say about their opposing candidates. But when you stream that same ad on your website or on through some streaming platform, if you're doing a simulcast of your over-the-air stream with some digital platform, there's some open question about whether that protection from liability extends to the streaming of that content on the internet. There is something called Section 230. That's the section of the Communications Decency Act that the president has been complaining about that gives on-air platforms insulation from content that they themselves do not create. That probably, or at least possibly, gives you insulation from liability for these ads that you can't censor when you put them over the air and you didn't create them. That content when it's streamed on the internet, but that's an unresolved question that we'll have to watch out for, because you know sooner or later that issue will come up. Now, there are other political advertising issues for digital media that you've got to consider. The Federal Election Commission already requires for paid digital ads that there be some sort of sponsorship identification. They've never said exactly what that sponsorship identification needs to look like, but there at least needs to be some clear and conspicuous identification that it's a paid political announcement if somebody is running a political announcement on one of your digital properties. There's various pending legislation to make that more robust, but I don't see any of that happening before the November election. But watch out, because many states have jumped into the seeming breach, the seeming gap in regulation by enacting their own requirements for digital political advertising. Check out the requirements in your state. We recently did a 50-state survey for a number of our clients and found that it's a morass. Every state has a different set of political advertising requirements. Some of them apply just to state candidates. Some of them apply to state and federal candidates. Some of them require, Washington State for one, has a very robust public file requirement for digital media advertisements, even if those are put on platforms outside the state, but advertised candidates running in Washington State. Maryland had a similar platform that was actually declared unconstitutional by a court in Maryland, but that's just for Maryland that law was thrown out. Virginia has got some disclosure requirements. New York has got disclosure requirements. Many other states have disclosure requirements. Many have stand by your ad. Hi, I'm so-and-so, and I approve this message requirements. Some even have lowest unit rate requirements that appear to apply not just to broadcasters, but to any platform accepting political advertising. So look at your state laws and figure out what applies if you're selling digital media to political advertisers. Moving on to another area, protecting the property that you've got, protecting your program titles, your branding statements, your slogans. You know, when you're broadcasting something, the people that hear the name of your program title are those people that are within the service area of your broadcast station. A couple of years ago, we had a station about a decade ago, I guess, that had never been online, and they had a disc jockey who used as his on-air name the name of a Greek god. And he'd been using that name for about 20 years. Nobody ever said anything about it. He was operating in this Midwestern state for a long time, no problem. They put their program schedule online on their website, listed the fact that this disc jockey using this Greek god's name as his on-air name was hosting the afternoon show. All of a sudden, they got a takedown notice from a disc jockey in Boston who had been using that same name for much longer than this guy in the middle of the country, and had actually trademarked the use of that name, telling this little station in the middle of nowhere to take down the references to it on the internet site and to stop using it in any sort of commerce, because it created issues for this big Boston disc jockey who was using it all over the place. Those things have happened in program titles and positioning statements and branding slogans, all sorts of things in the broadcast world. Make sure before you come up with a program title or a new slogan or jingle for your station that you check out, do a trademark search to make sure that somebody hasn't already trademarked it or otherwise or is otherwise using it, who may have superior rights to you and cause problems once you go spend a whole lot of money for advertising and developing a jingle package, only to find out that you've got to take it down because somebody else has been using it elsewhere. Also, you can use that offensively. It protects that. It protects it if you're using it online in national commerce. And if somebody else uses it someplace and you've got a federal trademark, you can make them stop using it or license it from you and have a revenue source. That's happened with certain slogans on weather, Certain radio station slogans have been trademarked and are sources of revenue for many of the big radio groups and some of the big television groups as well. So look at trademark both as a defensive and an offensive weapon that you should have in your arsenal. But also look at the rights that you've got in all the rest of your content that you're thinking about putting online. Because the rights that you've got in your broadcasts, your digital broadcasts for TV, your analog broadcasts for most radio stations, may not carry over into the fully digital world. For a long time, a lot of radio syndicated programs did not give rights to stations to allow them to be streamed, because some of the syndicated programmers thought that they would be able to develop their own sites where they stream their programming, and that would be another source of revenue for them. I think most now do allow you to do simultaneous streaming, a simulcast of your on-air stream carrying that syndicated programs. But every now and then we run into one that still does not allow you to syndicate that program. That may in fact be the case with certain major league sports. Look at the agreements to make sure that you've got the rights to carry that sport program on your online streams, because otherwise you may have to black that programming out if you're simulcasting your radio station. TV, it's the same sort of thing. You know, clearly you've got the rights to your local newscasts that you're producing yourself, but not all syndicated programs will allow you to stream them with video on demand and OTT platforms that are being created by most of the cable and MVPD systems. They want the rights. Make sure that when you're negotiating for syndicated programming and other programming that's developed outside of your full-time employees, you get the rights to stream that material, or at least to give the various MVT platforms the rights to stream that programming on demand to their listeners as part of your retransmission consent negotiations. That's usually an issue that comes up. And make sure that anything that you're posting in any sort of online platform that you have the rights to. Pictures, you know, you get a photographer, a professional photographer, to come in and take pictures of your disc jockeys or your newscasters so that you can put them in hang them in the lobby of your broadcast station, or put them into some sort of flyer, or put them up on a billboard. Look at the agreement that you got with a professional photographer. The fact that they gave you the rights to use those photos for one reason doesn't necessarily give you the rights to put them on your website. We had that issue come up again about a dozen years ago for a broadcast station that got the rights to the photos from a professional photographer to put them on into a flyer that they were sending around to listeners, to put them out in their lobby, the pictures of their disc jockeys. Nothing was said about websites. The photographer came back and said, hey, we still own the copyright to those photographs. You owe us more money because you've now put these photos onto the website. Get the actual copyright signed over to you if you're getting any content created by an independent contractor, somebody who's not doing it as part of their regular duties as a station employee. The copyright belongs to the independent contractor unless you've got a contract that assigns the copyright in any creative content to the station. Just like when you have your kids' photos taken at school, you can't run down to the local copy store and have copies of those photos taken because the professional photographer maintains the copyright, which is why you've got to pay outrageous fees to get those professional photos copied so you can send them to the grandmothers and aunts and uncles and everybody else. Make sure that you've got the rights to any programming that you want to put on your website or make available on demand. Make sure even that you've got the rights to background music and theme music to newscasts. You want to make your newscast on your TV station available on your website on demand, which many TV stations do. Fine, but make sure that whoever created that bum 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 news jingle or whatever that intros your newscast, that they've made those rights available not just for over-the-air use, but also to be used on your website. Otherwise, they may be back with their hands out looking for more money. So get the rights to any content that you're putting onto your website, and that extends to the rights that to any content that you may find elsewhere on the internet. There is this great mystery out there, this great misunderstanding, I should say, that once somebody posts all sorts of material on the internet, whether it's pictures or videos or a blog article, that, hey, it's a free-for-all. Once it's been posted, anybody can use it for any purpose. That's wrong. The creator maintains the rights to whatever they post, even if they're posting it on Facebook, even if they're posting it on YouTube, even if they're posting it on Twitter, they still have the rights. So you can't take a picture that you find on Instagram and copy that picture and drop it onto your website. You can't take a video that you find on YouTube and say, hey, this is the best video of the week, and run it on your newscast as the best video of the week, because the creator of that video still owns the copyright to that video. They may, as we'll talk about later, give YouTube the rights for YouTube to do whatever they want with that video, but they don't give you the rights to take that video and use it on your website or on your broadcast programming. There have been a number of TV stations that have gotten takedown notices or demands for money from creators of YouTube videos who found out that their video was run on a TV station. Even if you're doing summaries or links to news articles on your website or through your social media accounts, do just links with a very broad summary, one sentence summary. Hey, here's a good article on this topic. Go check it out. Don't take the heart of that article. Don't copy the first paragraph and post it onto your digital media property with a link to the rest of the article, because even that first paragraph is something that's copyrighted. And if that's the heart of the story, in the words of the story, that violates people's copyrights. That's why you'll see in most of these news sharing sites that the links and the descriptions are getting shorter and shorter. Sometimes it's just a headline and a link, or a very general one-sentence description and a link to the actual news site themselves. Why? Because the folks that post those summaries, those blog articles, whatever, they want people coming to their site so that they can monetize them. They don't want you to be able to get all the eyeballs, capture all the eyeballs, because you've given the guts of their story away, and nobody needs to actually click on that link to go to that site. Just adding a link to the original site doesn't give you any more rights to use that content. So don't use the actual content. Refer people in original wording, using as little of the original content as possible to those other sites. Photos are a huge issue. People are finding photos on the website and saying, Taylor Swift is coming to do a concert in town, finding some Taylor Swift photo somewhere on the internet and illustrating the story on their website with that photo that they found on the internet. The photographer who took that Taylor Swift photo is likely to come after you. There are what many of us legal types refer to as copyright trolls. They kind of hang under the bridge, wait for somebody to cross it and jump out and sue you. And that's basically what they're doing. They're hanging around, trolling the internet, looking for a use of one of their client photographers' photos on a website. And they've got these automatic bots that crawl throughout the internet looking for these photos that have been taken by the photographers that these lawyers represent. When they find them, they'll send you a demand letter, usually asking for $150,000 or $175,000 in damages. Usually you can settle it for much less than that. I don't want to get into numbers, but for significantly less than that. But if you don't settle it, some of these folks will take you to court. And while there are some defenses in certain cases, it costs money to litigate, and sometimes it's easier just to pay them the money and go away. I urge all of my clients to either take the pictures themselves that they're using on their websites or get the rights to those photos. Go to the manager of the band that's appearing in town and make sure that they send you an officially authorized photo to use on your website to illustrate the fact that the concert is coming in town. Go to a subscription service. There are a number of subscription services for photos, Getty Images, Shutterstock, and a number of others where you pay a monthly fee and you can use any photo within their catalog to illustrate various news stories. Yeah, it's going to cost you a couple $100 a month, but it avoids these copyright issues that are going to cost you a couple $1,000s at least every time you violate somebody else's copyrights. We've even seen some big companies, some of these photo sharing sites themselves, who have been found liable for millions when they thought they had the rights to a photo that they did not, in fact, have. There have been lots of big broadcast companies. Pretty much all of the publicly traded broadcast companies have had one station or another that has messed up and used a photo somewhere on a website of one of their stations that they didn't have authority to use. They've gotten sued by some of these copyright trolls. So go make sure that you've got the rights. Even social media sites. Don't take a photo from Instagram. Don't take a photo from Twitter. There have even been a couple of cases that suggest embedding a photo from Instagram or embedding a photo from YouTube. The freeze frame of a YouTube video where the picture of, there was a case of Tom Brady always came up when you embedded the video of Tom Brady doing something, that always came up there. You should be careful even embedding those photos, even though that stuff is served up from YouTube or Instagram's own servers, not from yours. There's been at least 2 courts that have suggested that you can be liable if you put those embedded photos on your websites, knowing that those photos will be there anytime some user comes to visit your site. So be very, very careful using any photos that you find elsewhere on the internet. I hesitate, I take a deep breath when I get into music rights, because music rights are incredibly confusing and they create a whole bunch of headaches for digital music rights. Now, you know that you've got public performance rights from ASCAP, BMI, CSAC, and at least in the broadcast, the radio side, GMR, for the music that you're performing on your broadcast stations. That gives you the public performance rights to the musical work or the musical composition. Basically, that's the words in the music, not the singer, not the band who's performing it, not the actual recording, but to the underlying composition. That's what ASCAP, BMI, CSAC, and GMR are giving you the rights to. When you're streaming your work on the internet, at least on the radio side, you're also paying Sound Exchange for the right to take the actual performance, the digital recording of like in Taylor Swift or Guns N' Roses or Mumford and Sons of a particular song and streaming that to your listeners in a digital, non-interactive fashion, you're paying Sound Exchange for the right to do that. When you look at your digital, when you look at your rights to do these things, they're very limited. While recently there's been some publicity, for instance, on the radio side, when the Radio Music License Committee entered into their recent deal with BMI for their new license, there was a press release that went out and said, hey, you get the public performance rights to all BMI compositions for broadcasting and on your digital media properties, including podcasts. And that's true, but it only tells half of the story. Public performance rights, the rights that you get from BMI, are not the only rights that you need to the musical composition, the musical work, the underlying words and music in a particular song when you do a podcast. In fact, you need what are called the rights to reproduce and the rights to distribute those musical compositions, the rights to make what are called derivative works, taking that musical composition and syncing it up with audio in a podcast or with video in any sort of YouTube kind of video that you're putting together. Those are all different rights that you can't get from BMI, ASCAP, CSAC, or GMR, or Sound Exchange for the actual song as performed by a particular band or artist. You've got to get them directly from the copyright holders, and it's usually a different copyright holder for the musical composition than it is for the sound recording itself. Usually the sound recording, at least for major label recordings, is held by the record companies. Usually the copyright in the musical composition is held by what's called a publishing company. You've got to get those rights directly if you're going to use it, the music in any sort of on-demand performance, either a download or an on-demand stream. Anytime music is played in a predictable order, where the listener can dictate what they're going to hear. Anytime you're making copies of musical compositions, all of that needs direct performance rights. Direct rights for the reproduction, distribution, derivative works, and in some cases even the performance rights from the copyright holders, because the performance rights and sound recordings that you get from Sound Exchange don't allow you to sync that audio up with a video. The performance rights that you get from GMR may not allow digital. The ASCAP performance rights are kind of, even for broadcasters, unclear as to whether they extend to all digital performances. So you got to get these rights cleared. So that's clearly the case for downloads. For podcasts, how do you get those cleared without having to call everybody that you want to, every publisher and every record company to get the songs cleared? Well, there are some online services where you can go to their websites and license songs on a track-by-track basis, or in some cases enter into a subscription agreement where you can use all the music that they've got in their catalog. And some of these services, there's one that I've actually done some legal work with called podcastmusic.com. They'll clear both the sound recording and the performance right in the musical composition so that you can use that music in your podcast. But they don't have the major labels right now for the most part. They've got some independent music, they've got some sound effects. There are a couple of other sites that do that as well. Look into those because that is one source. A lot of other podcasts commission their own music from local musicians who write their own music and perform it and get paid something by the podcast owner in order to get the rights. You'll see most of the NPR music, for instance, has local musicians who are recording the music that's used in the NPR podcasts. That's why you don't hear many big music podcasts. That's why most radio companies don't take their broadcast, their morning show, for instance, and put it on their website as a podcast, because you'd have to clear the rights to each and every individual song, and you can't really do that in any efficient way at the current time. Even video productions create these sorts of issues. Now that we're all doing Zoom or Facebook Live calls, or where you're doing them beyond your circle of family and friends, it's a public performance with video. When you're doing those, that you probably need a separate public performance right for. There may be some cases where the public performance right to the musical compositions may be covered in broad licenses. For instance, some college and universities may have the rights in their college and university licenses to any college and university right to those musical compositions. So if their college band is playing a particular song, or their choir is singing a particular song, or their radio station is playing a song, or music is playing in their cafeteria, that may be covered in their ASCAP, BMI, and CSAC agreement, and it may cover the musical composition when they're using it in a Zoom or Facebook live performance, but it doesn't cover the sound recording if you're using that in a Zoom or Facebook Live performance. It definitely doesn't cover either the composition or the sound recording, the master recording, if you're using that in an archived video. So lots of these Zoom calls, like this one that we're on today, or a Facebook Live call, or Google, Google Play or Microsoft Teams, or any of these video platforms that people are using these days, most of them allow you to archive it. If you're reaching out to your customers, if you're reaching out to your audience, doing these platforms and using music, get the rights to use that music in those platforms, or else one day you may have a composer or a record company or a performer come back to you with their hand out saying, hey, you owe music. You owe us money for using that music in that video that you're using. And sometimes getting the rights are easy. Some cases, especially with new songs, the songwriter is willing to do it, or the performer, just for the publicity. That's a lot of times when you got new bands that are touring, singing their own songs, who want to do a performance in your studio. You can get the rights from those artists to record their performances in your studio and put them up on your website. Again, make sure that they're singing their own songs and that they've got the rights to let you make your recording and the rights to allow you to record their musical compositions as well. You put them up on your website once you've gotten something in writing saying, yeah, you've got our permission to do so. But when you get established artists, when you're using pre-recorded materials, you got to go get the permission from those higher up in the publishing companies or the record companies. And sometimes, in a nonprofit use, it may be cheap. Other cases, it may be much more expensive. A lot of times I'll get the question, oh, it must be fair use if I'm using it. Particularly if I'm using it in a way that's funny. It's a parody. And because parodies can in fact be fair use. And what fair use means is that you can use it without getting permission from the copyright holder. And in fact, that's true, but that's only in rare cases. And it only applies under US law. Lots of these streams, lots of these websites are available internationally, and that can create problems because fair use is a US concept. Some other countries have some rights that are sort of akin to fair use, but it's not exactly the fair use that we've got here in the US. Even in the US, it's not something that you can conclusively look at, a use of a particular copyrighted song or words to a song or lyrics to a song or words from a poem or a couple of sentences from an article or a book or an excerpt from a movie and say, oh yeah, that's fair use. It's very difficult because it's a balancing test that courts use when you're already sued to determine whether or not you're going to have liability. And it depends on how much of the work you used, whether it's just a short amount, whether it's a long amount, whether you've used it for profit. If you're using it in a commercial, you're less likely to have any sort of protection under fair use than if you use it in a commercial. The effect of the use on the ability of the copyright holder to make money off of their copyrighted use. You use music in the background of a video or in the background of a commercial. Hey, songwriters license their music for those uses. If you're using it for free, it's not likely to be fair use because they can make money off of that. And then the nature of the work being used, whether it's music, whether it's spoken word, whether it's a book. And all of those factors are played in. It's really whether you're using it for a different purpose than it was originally intended. If you're using music to just play to entertain people by hearing it, it's different than if you use it, a clip of it in a commentary or criticism of a concert or of a new record album. Hey, listen to this song and hear how David Crosby's voice is not as good as it used to be, and you play 2 lines of the latest recording, that's more likely to be fair use than if you play 30 seconds of a song and then 30 seconds of another song or something like that. Or if you say, hey, here's a great new song from some local band, and then you play 45 seconds of that song. And that's your whole commentary or criticism. Hey, they've got a new record out. You play 45 seconds. That's unlikely to be seen as fair use. Then there's no such thing as an exception for 5 seconds or 10 seconds or 20 seconds or 30 seconds of a copyrighted work. There's some feeling that there is this automatic exception. That doesn't exist. It all is a weighing factor. And this whole idea of a parody. Hey, if I use it in a funny way, that's a fair use. No, you've got to be making a parody of the copyrighted work itself. You've got to make fun of the original work, not just use it in a funny way. And that happens all the time as I go to state broadcast conventions. A couple of years ago, I went to one where they were giving out awards for the best commercial. And there was a great commercial for a local liquor store using REM's The End of the World as We Know It. And it was like the end of the road at some town, which is where the liquor store was located. And throughout what sounded like Michael Stipe singing was a list of all the brands of the liquors that were being sold at this liquor store and all the other products that could be bought there. And it was a great, it sounded just like REM, but it was a copyright violation. It was used in a commercial. It was at least 30 seconds long. It sounds like the underlying music was taken right from an REM song or a karaoke version of the REM song. It would affect their rights to make money because they would license their songs for use in commercials. You can't do that sort of thing. A couple months later, I go to another show, radio show for the State Association, giving away the Best PSA Award. And the Best PSA was a TV spot for a animal shelter, a local animal shelter. And they took the old, remember the Lee Hazelwood, Nancy Sinatra song, These Boots Are Made for Walking, and did, of course, These Dogs Are Made for Walking. And it was, again, a great song, but as I'm sitting there in the audience, I'm thinking, oh my God, these guys are violating this copyright. The woman who made the PSA gets up and says, thank you to all of my staff for helping me put this PSA together. Thank you for the general manager for the idea of doing this PSA. And thank you to XYZ Publishing for giving me the rights to make a parody of their song. And I'm like, yes, somebody is actually listening to these seminars that I do and got the rights from the publishing company. If you're using it for a PSA, oftentimes you'll have more opportunity to get those rights for nothing than if you're using it in a commercial where you're going to have to pay for it. So get those rights. Don't rely on fair use. Everything that you're doing in the digital world, make sure that you're doing it thinking about what you're doing, not just signing on because everybody else is doing it. Beware as you're buying supplies or signing up for platforms or getting new digital tools that you're getting everything that you think that you're getting. Make sure that you're paying for services that you're actually going to use, not things that may be nice. Make sure that your suppliers know what they're doing, know what kind of rights are necessary to do a lot of this stuff, can provide the kind of metrics that you need if they're a streaming service provider so that you can do the reporting for ASCAP, BMI, CSAC, GMR, and Sound Exchange. Make sure that they've got the rights to everything in their platforms, and in fact their contracts give you indemnities because there's been all sorts of litigation in the digital world against all sorts of platform providers who let you stream music, let you stream video, let you make video or audio clips available on demand, let you do all these sorts of things, but then somebody argues that their platform itself was a platform that violated somebody's patent. And in patent, you can sue either the party who is creating the device that or platform or program that violates the patent, or a user of that patented project. So lots of digital media users, including lots of streaming media companies and lots of broadcasters. Particularly some of the broadcasters have been sued for patent violations for using digital music storage systems, for instance. Make sure that your services are up to date on what they're providing and that they keep up with the latest technology. And make sure and watch how long you're tied into a particular platform, because things get changed all the time, and you may sign up a long-term contract and find out that nobody's using it. You sign a long-term MySpace contract and suddenly nobody's using MySpace anymore. So watch out for those sorts of things. I see that there have been a couple of questions, so let me pick up on some of those. When using photos from a photographer on your website, do you need permission from the people shown in the photo? Yeah, it depends. If the people were in a public place, generally you don't. If it was clear that they could potentially be photographed, especially if they're in someplace like a concert venue. Most of the concert venues or sporting events will have something in their tickets saying, hey, you may be photographed in these venues. But if you're really focusing on somebody, rather than just having somebody in the background, it's better to get a release, especially if that person turns out to be somebody important, because as we'll talk about in a few moments, the rights of publicity can give people the rights to come after you. So be very careful in doing that, especially where those faces and people are, it's a close-up and it's very clear who they are. In fact, a couple of years ago, I was surprised watching an HBO documentary on Marion Barry, the former mayor of Washington, D.C. And at one point, the audio of the documentary said, and at some point, the white power brokers of the city turned against the mayor. And that video of that documentary, the white power brokers were two guys walking down the streets of Washington, D.C. in suits and ties. And I look at that video and one of them was me. Nobody asked me for the rights to put the video in the documentary, but it was two guys walking down the street in public. Probably they could use my photo without asking permission. But it was a shock to see myself in a documentary being an illustration of the white power structure of Washington, D.C. Another question, we're holding our 11th annual Hometown Showdown talent show virtually this year. Contestants sing, they provide the music, and it's never original. Yeah, you're doing that virtually, you're making that public. Your public performance licenses probably don't all cover you if you're doing it over a performance platform like a Zoom or a Facebook Live or something like that, especially if there's going to be an archived version of that being made. So it's better if you get the rights to a couple of particular songs, clear the rights, and make all the contestants sing those songs to which you've cleared the rights. So yeah, be careful, especially if it's going to be shared on your Facebook page or on your website. Be very careful on another question. They found a website where there's lots of photos. Be careful about sites that say that they're covered by Creative Commons licenses, because sometimes they don't have all the rights. Sometimes people post stuff on those Creative Commons sites without the host of that site knowing that the content that was posted, the person who posted it didn't have the rights. Sometimes those rights can be withdrawn from the Creative Commons sites. Sometimes they can't be used for commercial purposes. So if you're a commercial station, you can't use them. Sometimes they require certain acknowledgements that you've got to make sure that you get every time or provide every time you use those photos. So just be very careful with those Creative Commons sorts of sites. And again, relying on third parties who are creating their own content. Here, creating a PSA in support of the police. They say that they've gotten the rights to the photos. Probably you're okay in creating that, but it's always best to see those rights, to see that somebody has in fact given them the rights and that you've actually been able to see for sure that those rights have been created and given to you, that you're not relying on somebody else's rights. Moving on, be careful how you use social media in connection with your broadcast station. Every social media platform has their own rules and regulations. Those rules and regulations are changing all the time. Those rules and regulations provide ways in which you can use those social media platforms, and also the ways in which the platforms can use the contents that you're putting on those social media platforms that could infringe on your ability to do things with the material that you post. You need to be aware and constantly checking those social media accounts and their terms and conditions to make sure that you're not violating any of those terms and conditions. Facebook requires that any contest must specifically state that Facebook is not involved in that contest. They prohibit pages on firearms, alcohol, tobacco, and adult products, gambling, Prescription drugs promotions are all limited on Facebook. YouTube also puts limits on advertising or sponsorships, require you to buy specific kinds of essentially memberships in YouTube in order to post a lot of that kind of content. Each of the platforms have these requirements, but also be careful with what the services can do with the content that you're posting on these sites. Because these are the kinds of things that you'll see in the terms of use of these various platforms. First of all, you're warranting that you've got all the rights to anything that you post in Facebook or most of the other sites, so that if you use music in a video like a Facebook Live video and Facebook ends up getting sued for it, you're going to have to indemnify Facebook for all their costs, including attorney's fees, if it ends up that you don't have the rights. You give these sites like Instagram a non-exclusive, fully paid, royalty-free, transferable, sub-licensable, worldwide license to use the content that you post on or through the service. In other words, you post a photo to Instagram. Instagram, which is also owned by Facebook, can do anything that they want with that photo that you've posted on Instagram and made public on the Instagram platform. So you start posting videos or photos on these platforms, they can use them. They can put them into their own advertising, their own commercials, their own promotions. Twitter does the same sort of thing by posting, submitting, displaying content on the services. You give them a worldwide, non-exclusive, royalty-free license that they can sub-license to others to use, copy, reproduce, process, adapt, modify, publish, transmit, display, distribute the content any place in the world, any medium that they want to use it. You write this beautiful poem in the 240 characters that you put on Twitter. Twitter can take that poem and send it around the world, and you've given them a license to do so. So you gotta read these things and think about what you're posting on these sites. The same thing with YouTube. First, they warn you that you can't download and use their content unless they allow it. That's the concern I had earlier about taking a YouTube video and reproducing it on your TV station. And then you give them a right to take anything that you've posted on YouTube and transfer it to any of their platforms, which also are Google platforms. Google owns YouTube, so it could end up anywhere when you post that content. You know, that's why a lot of commercial entities have their own YouTube channels where they enter into particular contracts with YouTube that limit and restrict what YouTube can do with the content that's posted on their sites. You know, these excerpts from these terms of service were from about a year ago when I last did this presentation. They change all the time, but rarely do they get more favorable to you. Usually they get more favorable to the platforms. So you've got to be very, very careful with that content that is put there, because essentially it gives them the rights to do anything that they want with all that content that's put up on their websites. You know, I think somebody had a question earlier about defamation liability. You know, again, when you broadcast something and your disc jockey is ticked off at his or her neighbor for doing something, and they say some horrible, scandalous thing about the neighbor, if the neighbor or some friend of the neighbor isn't listening, it's said, it's gone, nobody knew that it was said. In digital media, if it's put into a podcast or streamed on demand or written on your website, it's there forever for anybody in the world to see it. Defamation you've essentially given people proof of exactly what was said that they can play over and over again if it's an audio or video fashion to make sure that you said exactly what they thought you said, and sue you based on what was said in that content. And if you're accusing somebody of criminality or not being truthful or having bad character or having some what the law calls a loathsome disease, they don't have to prove damages. They can sue you and get damages even without showing that anybody listened to it or that they had any particular degree of liability. You know, when you're talking about a public figure, about a president or a political figure or an athlete or an actor, the actor or public figure has got to prove that you posted something with what's called negligence. Basically, you knew it was untrue when you posted it, or you should have known that it was untrue when you posted it. So it gives them a higher burden to be able to sue for defamation, but they can still do it if you should have known, because everybody knew that this was a false rumor that was being passed around about this particular celebrity, but you went and put it on your website anyway. You can still have some liability. For a private individual, just saying something false about them, they have the right to sue you. Even where there is no defamation, as I said earlier about the question with the photograph. If you're using somebody's photograph from a public event and using it in connection with a commercial, hey, you know, every family needs this particular product, and you use the picture that you took at the local park of a family playing on the swings in a commercial. In many states, that's invading a person's right of publicity, and you can be sued for that. So be careful. Even retweets or shares of someone else's content can get you into trouble. And that's at the beginning. The case that I mentioned earlier came out yesterday. Joy Brown, the new host of the 6 to 7 o'clock hour on MSNBC here on the East Coast, was sued for a Twitter post that she, tweet that she did a couple of years ago, where she just retweeted a picture of a woman in a MAGA hat, alleging that this woman had used all sorts of slurs against a kid in the photo about his ethnicity. And in fact, that woman in the MAGA hat had not used slurs. And even the kid admitted that she hadn't used slurs. But this celebrity retweeted it and then added her own commentary on the retweet, saying it's outrageous that people like this are allowed to say these sorts of things, when in fact it turned out that the woman had never said it in the first place. And a court just said, even if it's a retweet, the mere fact that you've commented on it and possibly the mere fact that you've retweeted it can give rise to defamation liability, and to send it back to the court to see if in fact that liability lies in this particular case. So you've got to be careful, and you've got to make sure that all of your disc jockeys and on-air personnel and other folks who are tweeting in the name of the station or posting on Facebook or posting on Instagram or any of these other platforms are being very careful about what they say, because if they're tweeting as part of their job or using social media as part of their job, your station can be liable for those comments that are made. Be very careful about sponsorship identification. If you're paid to make social media posts or put stuff on your website, just like the FCC requires that you identify a sponsor if you get money to put stuff on the air or other valuable consideration, the Federal Trade Commission requires that you identify a sponsor for anything that's put online. A couple of years ago, they fined a product company $250,000 because they were paying affiliate websites to promote the services and how good those services were without disclosing that those promotions about, hey, this is the best shoe or the best guitar lesson or the best whatever that I've ever seen, without mentioning that that was promoted or that these people got something of value, even if it was they got entered into a contest where they could win something of value if the product found their sites out there promoting the product. That's something of value to the social media sites who are posting these links back to the home site of the product that can get you into trouble if you're doing that sort of thing. They enter into consent decrees that sometimes are 20 or 30 years long, unlike the FCC, where those consent decrees are usually 3 years or 5 years. And then be careful about testimonials in your ads. The Federal Trade Commission also looks at claim substantiation, making sure that in any sort of claim that's being made in a commercial or any sort of other promotion of a product, that the claim is essentially truthful, and where necessary, it's been substantiated, and it's particularly a higher level of concern where there could be consequences from a false claim, like if you're talking about health products, or if you're talking about, especially in the area of things like health products, if you're talking about, oh, this is going to cure your cancer, acne, COVID, if there's no expert consensus on it, don't be saying it or don't be suggesting that there's an expert consensus. Don't, especially where the consequences could be significant, and you can have liability as well as your advertiser. Usually the FTC is going to look at the advertiser rather than at you, but they can look at you for posting these misleading advertisements if you're directly participating in the deceptive content, or if you've got the ability to control that content. And you also need to be careful, as I said earlier, about celebrity endorsers. If your disc jockey is endorsing a weight loss program, make sure, first of all, that he or she used the weight loss program before saying, hey, I lost 20 pounds using XYZ systems or XYZ program. And also do more than say your results may vary. About 12 or 15 years ago, I think it's been, the FTC said, hey, just using a disclaimer like your results may vary doesn't cut it anymore. You've got to say what the typical user will experience using a particular product or platform. So you, again, be very careful in using any of your station employees to endorse products. Now, as we're coming towards the end here, just a couple of more topics. User-generated content. I mentioned this earlier in connection with political advertising. You can allow parties to post content on your digital media platforms and are generally exempt from liability for that content if you follow a couple of rules. One general rule is don't encourage that content, any sort of illegal content, to be posted on your website. For content like defamatory content, generally, if somebody is posting videos on your site that defame somebody else, or if they're posting essentially what would be comments to the editor in a newspaper, comments on articles or something that you posted on your website, or videos that you posted on your website, news reports that you posted on your website, you're generally exempt from those sorts of things that are posted by third parties. That's what and you can even edit them if you don't like the contents that are being posted in some of these user-generated contents, if they're obscene or indecent. And that's where the president has recently weighed in. He's concerned about sites like potentially broadcasters. If you start editing in a way that looks like it's politically biased or not clearly defined, He's suggesting that the Federal Trade Commission could come back after you for violating terms of use if you edited contents in ways that aren't clearly defined. He suggests that the FCC should adopt rules about what kind of terms of use you should have for user-generated content. None of that is binding law right now. It's all just a suggestion from the president that these things should be done. But watch how that develops. We could see some action going forward about this general immunity from liability under what's called Section 230. But this Section 230, this general immunity from liability, does not apply to intellectual property. That's covered under a different section of the law, under the Digital Millennium Copyright Act. Under the DMCA, you've got liability if somebody posts infringing copyrighted content on your website, like if they post a video where they don't have the rights to the underlying song of them singing a song, or a video, a music video of them dancing to a Prince song or something like that. You don't have any liability if you've got a policy in your policy statement that says, hey, don't post infringing content or other content to which you don't have the legal rights, that you didn't encourage that copyrighted content, like you didn't say, hey, post a great music video of you dancing to some of your favorite song or one of the songs that we play on our radio station, and we'll give a prize to the best music video. Don't do that. Get the rights to a particular song and have them make a music video of people dancing to that particular song to which you've cleared the rights. Because if you're encouraging people to dance to any song that you play on your station, you're essentially encouraging them to make music videos, which are derivative works where you need to get the rights directly from the copyright holders. You're encouraging them to violate copyright laws. You've got to notify the copyright holder of the name of a person at your company who can receive what are called takedown notices, notices from copyright holders who find infringing content on your site. There's an actual online registration process that you should use if you're posting these kinds of videos and stuff on your website. Go to the Copyright Office's website, find the registration system, and register your site with a person at your company who can be the person who gets these takedown notices. Put the takedown notices, that person also on your website. Take down offending material when you've gotten proper notification that it's in fact infringing. You can't be profiting directly from infringing content. So like, don't say, hey, post the best music videos from our songs we play, and then go out and start selling that to commercial advertisers in your market, saying, hey, we're getting all these great music videos created by folks in our audience. Wouldn't you like to sponsor that? Because then you are profiting from copyrighted material that's posted on your website. If you just got banner ads that pop up from DoubleClick or some automatically generated site that don't recognize what's copyrighted or not, that probably is not being profiting from illegal content. But if you're specifically selling after having encouraged somebody, yeah, you probably got some problems there. Be careful with content directed to children. There's something called the Children Online Privacy Protection Act that basically requires that any sort of online content that's directed to children under the age of 13, where you collect any sort of personally identifiable information about those children, you need permission from the parents, written permission from their parents before you collect this identifiable material. And that's very, very broad. Includes their name, their location, their social security number, a photograph, putting cookies or persistent identifiers on their devices, anything like that. You're identifying a kid who's come to your kid's site And you've got to get permission to do anything with that content unless you've got the written, and you can get into trouble unless you've got that written permission if you do anything with that information that's contained. And the FTC is very aggressive. They fined Disney $3 million. They fined Yelp almost $500,000 for violating these laws. So be very careful with content directed to children. Now, finally, just a couple of other issues to think about. Privacy is very, very important these days and is getting more important because there's more enforcement and there's likely to be more privacy laws coming your way. California already has some strict privacy laws. The European Union already has strict privacy laws, which is a lot of times when you're clicking on international sites, you'll see that you have to give permission for them to put cookies on your browser when you use their sites, and various other permissions have to be given. Be very careful as you're collecting any information about listeners' clubs or credit card information or any other identifiable information about people, that you're collecting that information and keeping it secure. Rather than collecting credit card information yourself, think about using PayPal, Eventbrite, or one of these other online systems for selling tickets or merchandise where you don't have to worry about being hacked, for instance, and giving up people's credit card information that you may have collected in connection with sales that you're doing on your website. Because if you're hacked and you've got personally identifiable information on your servers, you can have all sorts of liability, especially if it violates the terms of use, which I'll talk about on the next slide, on your website. And there have been lots and lots of lawsuits and actions by the Federal Trade Commission and others for sites that don't follow their terms of use about privacy of content that's been delivered. Be careful in your disclosures to allow private information that is collected to be transferred to any buyer of your radio station. So if you've got a listeners club or a bunch of folks who have signed up for an email list or a text list of alerts when certain things are going on your websites, make sure that, or going on your stations, make sure that you've got the rights not just to text these people back or email these people back, but also that you've got the rights to transfer the rights to do these things to any person who buys your radio station. There are more laws being developed, like California's, about a right to be forgotten. So if you've got revealing information about a person and they want to delete it, you've got to be able to delete it. More laws are coming your way. Make sure that your privacy policy really discloses the privacy issues on your site, and that it's accurate, very accurate, and not what we say here, aspirational. It doesn't say, oh, we've got the best privacy on all of our material, then you'll never have to worry about it, when you've got some standard server that you've bought somewhere and it's protected with you as a password, with your dog's name that somebody can see on Facebook, or your wife's birthday, or password is your password or something like that, or 1, 2, 3, 4. If that's all that's protecting your private content, and somebody can break into your server and get access to that, and you've said you've got the best privacy and are using the higher standards of privacy, you're looking for a lawsuit. So be very, very careful and outsource this wherever possible. Be careful as to how you're developing these products. There are more and more consultants. There are more and more lawyers. Our law firm has got several lawyers who help clients develop privacy policies and also security policies for their websites to make sure that sites can't be broken into, that if they are broken into, that they've got policies in place as to what the company will do if there's been some sort of data breach, to notify their customers, to notify people whose personally identifiable information has been obtained through some sort of data breach. You know, looking at these kinds of security failures that can get you into trouble, having weak passports, having easily bypassed authentication, ignoring vulnerability reports that you may get from vendors, failing to notify customers of vulnerabilities or breaches, exposing too much information without hiding it when you should be hiding it, you know, failing to have this extra security for sensitive data, being careful about using vendors who know what they're doing. Lots of consultants are out there to help check out their credentials, make sure that they know what they're talking about, and look into these things, because we're seeing, I mean, you probably get breach notices all the time from various folks that you do work with, whether it's social media platforms, insurance companies, banks, law firms, accounting firms, you know, all the credit rating agencies had those problems a couple of years ago where they got hacked. It's happening to everybody, that they're getting hacked. Use consultants, develop programs, educate your employees not to fall for phishing emails, phishing emails, where you click on what appears to be a link to some site you use, and in fact it installs malware on your computer that allows the some hacker to get inside your system. Be very, very careful on all of your digital and social media platforms that this stuff does not happen. So in short, I've given you an awful lot to think about in the last hour and a half. There's a lot of issues out there. It's not always clear who's in charge. We've got new laws arising every day. And I've only talked here about US laws. As digital media is available throughout the world, you've got to worry about laws from Europe. You've got to worry about laws from Canada. You've got to worry about laws from Mexico. You've got to worry about laws from all over the world as well on your digital media platforms. So proceed with caution, use care, hire people that know what they're doing to give you advice. More information, here's my contact information. Here's my blog as well. I write about these issues on a regular basis. In fact, wrote a little bit about Zoom earlier this week and some of the music royalty issues that you can face there for those state associations where I provide hotline services. My direct dial number is also here on the screen. Happy to help any of you if you're looking for a lawyer or just some simple advice. There I am. Thanks so much for listening. Thanks, Dan.
David, great presentation today, and I think there was a lot there to swallow, but I think you did a great job, so thank you so much. To everybody on the webinar today, we will be mailing out a link to the video of this presentation between now and Monday, so look for that in your inbox. And that is it from Michigan today, and from DC, I guess, too.
Yep, and just remember that that link in this video is not legal advice. It's just helping you spot issues. Make sure you talk to your own lawyer for legal advice. There's my last disclaimer before I sign off. Everybody have a great afternoon.